Professor Tracy here, back with another lesson regarding contracts, this one about the adequacy of consideration. Before we delve into the doctrine of adequacy, let's look at where we've traveled so far. We started out by looking at the definition of a promise. We said that a promise is the basic building block of a contract. That is, that a promise is a manifestation of an intention to act or not act in a specified way. And we said that we view that manifestation, that outward expression, and we ask whether or not the promisee, the person to whom the promise is made, is justified in believing that that manifestation is in fact a commitment from the promisor to act or not act in a particular way. And we said we judge that objectively. And so we ask whether a reasonable person in the shoes of the promisee who is looking at that manifestation, giving the ordinary meaning to the ordinary words that are used, the technical meaning to any technical terms that are used, and aware of all the surrounding circumstances, whether they would believe that a promise is made. And once we've decided that yes, there is a promise, we said that not all promises are legally enforceable, meaning that not every promise that is made to you and someone fails to follow through on it, can you then run into court and seek to legally enforce, to have the court either order the person to follow through on their promise or to provide you some sort of remedy for their failure to follow through, to breach that promise. We said instead we have to distinguish between contractual promises, which as a general matter are legally enforceable, and gratuitous promises, which are as a general rule not legally enforceable. We said that to be contractual means that a promise is part of an exchange and part of a contract. We said there are three elements to contract formation. Those are offer, acceptance, and consideration. Our emphasis and our look so far has been at consideration. We said what that means when we were asking, is the promise, has it been given in exchange for consideration? Or we say, is it supported by consideration? Meaning, is it part of an exchange? Was it given with the expectation of receiving a return promise or a return performance? And so if it's part of this trade or exchange or bargain or barter, whatever we say, then that makes it likely that it's contractual in nature and therefore enforceable. We said then we need to identify what consideration is in order for us to know whether the promise is supported by consideration. So we defined consideration as having two broad elements. The first being that it must be that the promise is part of a bargained for exchange. That is, that the promisor's promise induces from the promisee a detriment, meaning that the promisee incurs some legal obligation that they didn't have before. Either that they've made a return promise to which they will be held, so they will have a legal duty to perform the promise they've given in exchange, or they will be providing a return performance. And so that would be the detriment. But we also said, in addition, it must be true that the reason the promisor made the promise to the promisee in the first place is that they expected to get this detriment, this return promise or return performance. So what induced them or motivated them to make the promise in the first place was this desire for that detriment coming back to them from the promisee. And we said, in addition, the second part of consideration is that which is being exchanged, the promises or the performance in exchange for the promise, must be of legal value. And the law generally defines that as something being of benefit to the promisor, a positive thing for them, or that it's something that is a detriment to the promisee, which undoubtedly will almost always be true if we've satisfied the elements of a bargain for exchange. So to some extent, you could say, well, isn't this just a formality? Maybe. That may be the case, but it's important because some states, in fact, divvy these things out, divide them up, such that we need to make sure we're identifying them separately, even though you could certainly lump them together, and some states do. But for the purpose of just being thorough, I'm dividing them out here. So we looked in the last lesson at conditional gifts, and we were looking, remember that in some ways a conditional gift can look like a contractual promise, but we explained why it's not, why there in fact isn't consideration given. So we're going to first look here at a example where the condition is one that is outside the control of either Barb or Bob here, and then we'll look at one where the condition is inside the control of the promisee. And we said those are the two types of events that can be conditions. So here Bob says, "Hiya, Barb." "Oh, hey, it's you again." "Barb, if it doesn't rain tomorrow, I will take you to the beach." So we know that there's a promise there coming from Bob, which is, I promise to take you to the beach if it does not rain tomorrow. So he's made a promise, right, which we've noted there with the yellow arrow. And the question we have to ask is Barb giving anything in exchange? And the answer there is no, right? There's a condition there, which is if it doesn't rain, but that doesn't demand anything from Bob, right? There is a condition that says, only if it doesn't rain will I be taking you. That's an event that must take place before this promise is something to which Barb would be entitled to. But there's nothing she's giving in exchange. And indeed, Bob isn't making his promise to take her to the beach with any expectation of receiving anything in exchange. So this is purely just a gratuitous promise, right? If it rains, then she's not entitled, right? We're cutting off the promise there. And if it's sunny, then she's entitled to it. But keeping in mind that entitlement is not a legal entitlement. It's just still, despite the condition, just a gratuitous promise that is not legally enforceable. It has no consideration. Why? Because Bob's promise didn't induce any kind of detriment from Barb, right? So the first part of a bargain exchange is missing. And indeed, he didn't make the promise seeking any kind of detriment, right? So neither part of a bargain for exchange is present. So we said the second example we're going to look at here is one where the condition or the event that must take place is within the control of the promisee. So here Barb says, "Bob, I just bought a new piano. I will give you my old one if you come by my house on Saturday to pick it up." So here we have a promise from Barb, which is, I promise to give you my piano. And there is something that is expected of Bob, right? Because it's a conditional gift of a piano, which is it calls for Bob to come by Barb's house on Saturday. So there is something given in exchange, but we've got to say, is if he commits to going by her house on Saturday, is that in fact consideration for Barb's promise, such that we would say, well, her promise is contractual in nature, it's supported by consideration, it's therefore legally enforceable if she doesn't in fact end up giving Bob the piano. And so we said, well, he's got to come by the house. If he doesn't, then he's not he's not met the conditions of that promise of a piano. But if he does come by, then he would be entitled to it but the question is still, okay, it's got a condition, but we saw with the previous one that just because there's a condition, then it may be satisfied. Does that mean that it's a contractual promise, or might it still be gratuitous? And here, poor Bob, we need to note this. This is important. We can say that Barb's promise of a piano does induce a detriment from Bob, right? So that part of the bargain for exchange is met, right? That Barb's promise induced a detriment, meaning that Bob is obligating himself to come by Barb's house on Saturday to pick up the piano, which is an obligation he did not otherwise have. But we said that typically with this kind of conditional gift, where the condition is within the control of the promisee, which it is true here, Bob, and we said, well, what makes it not work as a bargain for exchange is that detriment of Bob coming by our house is not what's motivating Barb to make the promise of a gift in the first place. So it is not the case that the detriment, that the promisee, Bob's detriment, is what induced her to make her promise of a free piano. So that's gone. And that means there can't be a bargain for exchange because we need both parts of it. And that means there wouldn't be consideration, and that her promise then is gratuitous. And importantly, remember that even if the condition is met, either with the example of the promise to go to the beach, and if it's sunny or not, and let's say it's a sunny day and it's not raining, or with the piano, if Bob does in fact satisfy the condition and come by her house, it's still a gratuitous promise, and there's no obligation for Barb to follow through on it. We said in the last lesson that sort of one of the exceptions there would be if she already gave him the piano, then she wouldn't be able to come back to him and say, well, it was gratuitous when I made the promise. We said, no, in that case, once a gift has been given, then the argument that it was the promise of the gift was gratuitous isn't going to work, right? At that point, the genie's out of the bottle, so to speak. So let's drill down then at the doctrine we're looking at in this lesson, which is adequacy of consideration. We're going to look at a chart here that gives us the possibilities. When we talk about adequacy, what we're asking is the value of the thing given in exchange for the promise, do we look at the value and say, is it adequate enough that we can say, yes, we should treat that as consideration for the promise? Do we do that? Do we look at the relative values of the things being exchanged and say, should we really treat that as being sufficient or adequate to satisfy the element of consideration? And obviously, if it's a completely equal exchange, there's not even a question about adequacy. So if we look at this example, Barb, I'm selling candy bars for $1 each. Are you interested? Sure. That sounds like a fair price. So there, it's in terms of adequacy, that is, the consideration, her promise to pay $1 and his promise to provide a candy bar. We can say that's essentially an equal exchange, and therefore, in terms of consideration, it appears that the element is met, right? That it's completely equal and it's enforceable. So all the elements of consideration would be met, and that Bob's promise induced a return promise from Barb to pay $1. And the reason he was promising a candy bar was in fact because he wanted her to commit to paying $1. And the $1, obviously the promise of her to pay the $1 would be a benefit to him and would be a detriment to him. There's no law in the universe that Barb had to pay Bob $1. So all those elements of consideration would be met. Now, we could have what we might just deem an unequal exchange where the things are not exactly of equal value. So what do we do in that case? Do we say, well, because it's not perfectly even, therefore what's being given is not adequate? There's an uneven exchange, therefore consideration isn't met? And no, you can see on the chart, we don't do that, right? The general rule is that adequacy of consideration does not matter. The court does not delve into that when asking, is the element of consideration met? So even if it's uneven, look at this example. Bob says, hello again, Barb. I'm selling candy bars for my soap carving club. They're $5 each. Are you interested? Yikes. $5 for one candy bar? It's pretty steep, but it's for a good cause. I'll take one. So there we can say, $5 seems, a little much for a candy bar, assuming it's an ordinary size candy bar. Then we would look at that and say, yeah, it's uneven, but our general rule holds that in terms of asking whether the element of consideration is met, we're not going to say, well, Barb is paying way more, more than it's worth, so Bob's not giving adequate consideration for the $5 he's asking for from Barb. We would say, just like the previous example, all the elements here of consideration are met. So what about what we might term gross inadequacy, meaning that there's not just a minor unevenness or unequalness to the exchange, but a shocking inequality in what's being exchanged. We need to understand that, again, typically adequacy is not going to be an issue. That's our general rule. It would prevail here, so it would still be enforceable. But the thing to note is that people typically don't enter into contracts that are completely one-sided. If they do, it should raise a red flag for us. It should make us think, why did they do that? That may indicate that there was some fraud or misrepresentation or some level of compulsion or duress, that they either felt pressured into the contract or were pressured into the contract or misled as to what the contract was about, and they entered into it. So it should raise a red flag for us that perhaps there is a defense. Nonetheless, in terms of whether the element of consideration is met, the answer is yes, even though there's a gross inequality or inadequacy involved. So we can see that here. Bob says, I'm still here shilling candy bars. I'm now asking $100 for each candy bar. What? Come on, I need the money, Barb. Help a poor guy out. How am I supposed to buy soap to carve without money? I guess so. I'll take one, but only because we're friends. So there you can say, $100 for a candy bar. It is grossly uneven, right? That Barb is not getting anywhere close to the value of $100 for a candy bar, unless it's a gigantic one. But nonetheless, our general rule holds that the adequacy of the consideration doesn't matter, so it would be enforceable unless a defense applies. So it raises a red flag that perhaps that there was some compulsion or misrepresentation here. That wasn't true in the hypo I just laid out, but nonetheless, when you're looking at fact patterns either on an exam or in real life, and you see someone entering into a contract that's very one-sided, that should raise some red flags to you and make you want to scrutinize that pretty closely, because that's not the kind of thing people do, although here perhaps Barb did it just to be kind. So here we would say, all the elements of consideration are met, even though there's a gross inequality. The only thing that has changed is that we have concern that perhaps there was some sort of compulsion or pressure or deceit that might mean a defense is applicable. We'll talk about defenses down the road. So our last category here, though, is what we might term nominal consideration. And what we have in view here is a situation where the consideration being given in exchange for the promise is really just a token amount that the promisor is really intending to make a gift, and the parties decide they want to dress it up to make it look like a contract. So ask the promisee to give some sort of token amount, which is really what we would term a sham or a pretense, because the promisor is really intending to make a gift, doesn't really care about this token amount of money, like $1 or $2. And so in which case that would be a situation where we'd say there is no consideration. And you could say, okay, that's an adequacy problem. But the reason we would say there's no consideration is because we would say that the promisor isn't motivated to promise whatever it is because they really want the $1 or the $2 or $5 or whatever it is, that nominal amount of money. They really just want to make a gift, and they just want to dress it up. And so it's really just a pretense or a sham of a contract or of some kind of consideration. So we can see here, Barb says, I got my new car over the weekend. You still want my old one? Of course. It's still free, right? Well, I've been thinking about that. I'd feel better about it if you gave me $1 or $2 just to make it look more like a contract. I don't want anyone to get the wrong idea. You know what I mean? I'm not sure I do know what you mean, but if it makes you feel better, I'm happy to pay you $1. Thanks. I appreciate that. So there, that wouldn't be enforceable. Why? Because Barb is intending to make a gift and she's requesting $1 or $2 from Bob, but she's not motivated to promise the car to him because she really wants that $1 or $2. So this is the only place in our chart about inadequacy where we would say the element of consideration isn't met. Why? Because that token amount or nominal amount is not really what induces the promisor to make the promise. So we can look at our elements of consideration and say here, is it true that Barb's promise induces a detriment from Bob? It is true. It's a slight detriment. It's just a promise to pay $1. But nonetheless, he was not otherwise obligated to pay her $1. But what's missing is the second part of a bargain for exchange, because she's not promising him the car because she really wants that detriment of the $1 or $2, right? So we would say the second part is missing. So there can't be a bargain for exchange because we need both parts of it. And that means there's no consideration. So that promise is merely gratuitous and therefore wouldn't be legally enforceable. So that's it for now. I hope that's a helpful lesson on adequacy of consideration and a quick review. And as always, if you found it helpful, if you enjoyed it, I ask that you would like and subscribe, and I'll be back soon with another lesson. Talk to you soon. Bye.